Hello, practical law students. So this is the third and final lesson for this week. We have spent some time defining what crime is. We've defined crimes against the person. We've defined crimes against property. Earlier this week, we looked at wrapping up crimes against property. The second lesson for this week, we began talking about defenses. So if you've been charged with a crime, what defenses do you have in court? We looked at no crime has been committed because remember, for a crime to happen, you must have the illegal act and the intent. So if you can prove that the act wasn't illegal or that the intent was not there, that means no crime has been committed. Okay, and that's your defense. We talked about defendant not committing the crime, namely, we've got an alibi, we've got DNA evidence, we've got some sort of proof that the defendant was not there at the time the crime was committed. And we talked about the defendant committed the act, but it was excusable or justifiable. Either they were defending themselves, they were defending somebody else, or they were defending their property, and they used force, but that force has to be reasonable and not over and above the force that is being used against them. Okay? Well, today we're going to wrap up defenses by looking at the defendant committed the act but is not criminally responsible. Now, like we've been doing so far, you're going to take your own notes as we go through this. I will try to give you a heads up with what I want you to copy down. Again, there's going to be a lot of definitions on this one. So just as you work through, jot some notes down, define some of these crimes or define some of these defenses. And we're going to talk about the defendant committed the act, but it is not criminally responsible. Now, when we talk about the defendant committing the act but is not criminally responsible, what we are discussing is the defendant's lack of criminal responsibility. What does that mean? Well, we acknowledge that he or she committed the act, that it was criminal, but they should not be considered criminally responsible for one of many reasons. And those reasons are infancy, intoxication, insanity, entrapment, duress, or necessity. Now, using these defenses does not necessarily mean the defendant is going to get off scot-free, but it might mean the difference between a death penalty and life in prison, or life in prison in some other prison term. Or maybe even, we're not going to send you to prison, but we are going to put you in an institution for your health. Okay. Now, don't worry about copying anything down on this slide. I'm just giving you an overview of what we're going to talk about. So the act has been committed, but for some reason, the defendant should not be held criminally responsible. And we're going to start with infancy. Now, what I want you to get down with infancy is this. Children under specified age have the defense of infancy. Now, this varies from state to state. What that means is children under specified age shall not be tried for their crimes, but shall be turned over to the juvenile court system. Historically, age 7 and under were legally incapable of committing a crime. So if you're 7 or younger, you're legally incapable of committing a crime. Ages 7 to 14 were presumed incapable of committing a crime, but if it was shown that they knew that the act was wrong and they had the intent to do it, regardless of the fact that they knew it was wrong, it is possible they could be charged with a crime and be sent to juvenile court. Okay? Now, some states do not have the defense of infancy at all. And some states allow the prosecutors to decide whether to try a child as an adult, giving them more discretion to deal with juvenile delinquency on a case-by-case basis. Okay, there was a famous episode, if you like the show Law and Order, I remember this episode of Law and Order. This little boy who was between the ages of 7 and 14 was caught basically killing his baby sister. He got tired of the sister crying. He got tired of the attention that was paid to the sister, and he picked her up and shook her to keep her quiet. He knew that he should not have done it. He knew that by doing that, she would probably get hurt, and he hoped to shut her up. So, and this might have been dramatized for TV. It probably was, but the prosecutor successfully proved he knew it was a criminal act and he had the intent to do it anyway. So even though he was between the ages of 7 and 14, he was tried as an adult. Okay. So that's why we say these laws are going to vary, but in general, children under a specified age are incapable of committing a crime. All right. 18 is also a big age because when you turn 18, it's presumed that you are an adult. And age 18 or over, juvenile court system goes off the table. Okay. And you're going to be charged as an adult anyway. Okay. So this is what we're talking about when we talk about defendant committed the act, but is not criminally responsible. If you're under a certain age, you cannot be held criminally responsible for the act. Okay. Now let's talk about adults. All right. Infancy is kind of easy to understand for kids. Let's talk about adults. All right. Let's talk about intoxication. All right. Now with intoxication, the defendant claims that at the time of the crime, they were so drunk on alcohol or high on drugs that they did not know what they were doing. Now, voluntary intoxication is usually not a valid defense for a crime. It can sometimes be used if the crime requires proof of a specific mental state, but if you come in and you say, yes, I was totally getting drunk or I was totally getting high, that does not matter. What we're talking about is if you got slipped something on accident, you did not know that you were high, you did not know that you were drunk, and then you committed a crime. That's what we're talking about, okay? An example. Grady is charged with assault with intent to kill and claims he was drunk. If he can prove that he was so drunk that he could not have formed the intent to kill, his intoxication may be a valid defense. He can still be convicted of the crime of assault because specific intent is not required to prove the crime, but he cannot be charged with assault with intent to kill. Okay? That's what we're talking about. That you were so drunk or high at the time, you did not know what you were doing. Okay? That's what intoxication is. All right? And to be honest with you, you don't have to worry about copying anything on the slide down. All right. All right. Let's talk about insanity. The modern standard grew out of an 1843 case involving the attempted murder of a British prime minister. The idea behind insanity is people who have a mental disease or disorder should not be convicted if they do not know the difference between right and wrong. That's the definition I want you to get down. People with a mental disease or disorder should not be convicted if they do not know the difference between right and wrong. About half of the states and the federal government will use this standard. Other states hold that the accused person must be acquitted if they lack substantial capacity to appreciate the nature of the act or to conform their conduct to the requirements of law, which basically means the intent. Okay? So some states allow it, some states automatically say the person's going to be acquitted. Okay? If they do not appreciate the nature of the act or they do not conform their conduct to the requirements of law. The insanity defense can be used to determine several things, okay? Number one, is the defendant even competent to stand trial? We may not have a trial to begin with. Number two, the insanity at the time of the trial may delay proceedings until the accused is competent to stand trial and understands what is taking place, okay? So, is this a permanent state of mind, or did it happen in regards to this specific incident, and at some point in time, the defendant will be able to stand trial. Okay, was the defendant sane at the time of the criminal act? All right, that's the big one. Okay, were they sane or were they insane? It applies only if the accused was insane at the time of the crime. Okay, so the insanity defense only applies if the accused was insane at the time of the crime. Is the defendant sane after the trial? Okay. We're going to look at that. Insanity during or after trial does not affect the defendant's criminal liability. Okay. yes, you still commit the crime. All right. And that's what we're talking about with all of these defenses. You committed the act, but you're not criminally responsible. Okay. So that's what we're saying is yes, you did commit the act. All right. Um, but we move on to the verdict stage. You could be found guilty, innocent, or not guilty by reason of insanity. Okay. You're still going to be charged with the act, but you could be found guilty, innocent, or not guilty by reason of insanity. In some states, the last verdict, guilt by reason of insanity, results in automatic commitment to a mental institution. Some states, about a third of states, have a new verdict, guilty but mentally ill. Okay, guilty but mentally ill. In that case, defendants are sent to a hospital and later transferred to a prison once they are judged sane. The defense must produce evidence of a mental disease or disorder, and psychiatrists are usually called to give testimony, and the decision as to whether insanity is a valid defense rests with whoever, the judge or the jury, decides the facts in the case. Right? Now, in this country, the insanity defense was first used in a trial involving a Washington politician by the name of Daniel Sickles. Daniel Sickles, his wife, was carrying on an affair with the son of Francis Scott Key. Francis Scott Key wrote our national anthem. And Daniel Sickles basically shot Francis Scott Key's son to death in broad daylight in a street in Washington, D.C. In fact, close to the White House. And then argued successfully that the knowledge of his wife's affair with the man drove him to kill him, and he had no idea what he was doing at the time. And his lawyer successfully argued the insanity defense, and Daniel Sickles went off scot-free. In fact, he later goes on to serve as a general for the Union Army during the American Civil War. Okay, and actually lives up until the early 1900s. Okay, so that was the first instance of the insanity defense being used in the United States. Now, 4 states, Montana, Idaho, Kansas, and Utah, have abolished it entirely in their state courts. All right. Now, to be honest with you, this defense is seldom used. And when it is used, it is seldom successful because of the amount of proof that is needed to prove insanity. So it is seldom used, and if it is used, it is seldom successful. Okay. And the potential, to be honest with you, it's a no-win-win situation because, like I said, if you are found guilty by reason of insanity, you're going to be sent to a mental institution. Okay. Or they've got that new defense, you can be found guilty and sent to a mental institution, and then once you are deemed sane, you can be sent to prison. All right. So, like I said, it is seldom used, and when it is used, it is seldom successful. Now, the last 3 are difficult. I'm just going to throw them out there. I know there are a bunch of questions about these. So if you have them, please let me know. We're going to talk about entrapment, duress, and necessity. Entrapment applies when the defendant admits to committing a criminal act but claims that he or she was induced or persuaded by a law enforcement officer to commit the crime. That's the definition. That's what I want you to get down on this slide. Okay, what is entrapment? You committed the criminal act, but you were induced or persuaded by a law enforcement officer to commit the crime. It is not entrapment when a police officer merely provides the defendant with an opportunity to commit the crime. Okay? If they just mention it in passing, that is not entrapment. It must be shown that the defendant would not have committed the crime if not for the inducement of the police officer. The police officer has to go through and actually do something else to get the defendant to commit the crime. And that's going to be difficult to prove. Okay? Now, with entrapment, duress, and necessity, it cannot be claimed as a defense involving crimes with serious physical injury, such as rape or murder. And this is where a lot of people have questions. Okay, why can it be used in this in these situations? Is it possible that under force a police officer could get you to rape somebody or murder somebody? And the answer is there's always, and I know this doesn't make sense in a lot of cases. The feeling is there is always an alternative. You should be able to go to somebody else and say, "Hey, this is happening," and avoid the murder. You should be able to, go to somebody else and avoid the rape. Okay, that's the understanding, is that in those serious crimes there always should be a way out. And I know that's difficult to understand, and I know I can't define it any more than that, but that's the understanding. Okay, is that there has to be an alternative besides carrying out the rape or the murder. Okay, so entrapment, you committed the criminal act, but you were persuaded to do so by a law enforcement officer. Okay. Duress is kind of the same thing. Okay. The defendant does something as a result of coercion or threat of immediate danger to life or personal safety, but it's not necessarily by a law enforcement officer. Okay. So get down this definition of duress. The easy way to define this is that the individual lacks the ability to exercise free will. Okay. It may also be used as a defense if the threat is made to a third party member, such as a family member. So this often happens with kidnapping cases and things like that. Like, you will commit these crimes for me, or I will harm your children, or harm your wife, or harm your husband, or whoever. Okay. So it can be a defense if another party is involved. But once again, it is not a defense in homicide. Again, the understanding is there always has to be an alternative. All right. You should have time between the threat and actually carrying out the act to warn somebody or get somebody else's help. Okay. Like a law enforcement official. All right. So it is not a defense in homicide. So duress, you commit a criminal act as a result of coercion or threat of immediate danger to life or personal safety for yourself or someone else. Okay. Necessity, and we kind of talked about this with excusable homicide. Necessity is a defendant is compelled to react to a situation that is unavoidable to protect life. So, killing an enemy in war, if you're a police officer and you kill a suspect who's going to kill you or kill somebody else, that is necessity. Okay. Once again, it is not a defense in homicide. All right. Now, I will say, it's not a defense in homicide. Remember your definition of homicide. Okay. Homicide is the taking of somebody's life with extreme malice. Okay. You got to be able to prove malice existed. All right. So it is possible, if you can prove that the killing of somebody was not actually a homicide, then necessity, entrapment, duress may be acceptable defenses. Okay. All right. So there are, I guess, safety nets in place. If you can prove that the killing was not actually a homicide and does not meet the characteristics of homicide, then necessity, duress, and entrapment would work. Okay. But if you can't prove it wasn't homicide, they're not going to work. All right. Now, that's it for defenses. Okay. That's going to wrap up the lessons for this week. Next week, to be honest with you, we're probably heading toward a little quiz on all this material. So stay tuned to the module for next week, and we'll talk about where we're headed from here.